just know that it takes a minute for things to populate.
It's on blank right now.
All right, anything from council before we bring the jury in? Okay, nothing from the state. Let's bring the jury in, please. Okay, please be seated. Thank you. Okay, please be seated. We're ready to continue now to the defense closing argument. And Ms. Kawase, you may proceed.
Thank you, Your Honor. May it please the court, opposing counsel, members of the jury, good morning. Good morning. Now, before I get started with my closing argument, I wanted, on behalf of myself, my co-counsel, the court, everyone in this courtroom, and especially my client, Katherine Magbanua, to say thank you. If it were not for jurors just like you, the justice system would come to a grinding halt. Each of you dedicated the time out of your own lives to sit here and to listen to the evidence in this case. And I can guarantee you that there is not one person in this room who is more grateful than Katherine Magbanua. This is not an easy case. You have been here each and every day for 2 weeks, always here on time, very, very long days, tons of witnesses and evidence, and each of you came in every day, down and pay attention and listen. At the beginning of this case, I told you that there would be only one question that you would have to answer at the close of all the evidence. Did the state prove to you beyond and to the exclusion of every reasonable doubt that Katherine Magbanua knew about and helped commit the murder of Dan Markel? I also made it very clear at the beginning of this case that the only evidence that the state would present to you that Katherine Magbanua was allegedly part of this are the words of the convicted murderer and gang member, Luis Rivera. And I was right. So let's start at the beginning, because you have to start at the beginning to understand what happened here and how an innocent woman ended up having to fight for her life for something that she did not do. This, members of the jury, is an analysis prosecution. Now, do not get me wrong. The investigation that was initially done by the Tallahassee Police Department led them directly to Sigfredo Garcia and Luis Rivera. They also already had their main suspects, the Adelson family, more specifically, Donna and Charlie. But how were they going to connect these two groups of people who seemed to have nothing connecting them? And the easiest answer that they could find and that they went with was Katherine Magbanua. Now, we went over in jury selection, and we talked about this at great length, how important it is for the police and the prosecution to be objective when they are investigating. The police and the prosecutors, they are the ones that hold this awesome power to take away the liberty and freedom of the citizens of this state. And with that great power comes great responsibility. The responsibility to make sure that they remain objective and investigate everything. Because it is more important. One of their jobs is to protect Ms. Magbanua, to ensure that innocent people are not convicted for crimes that they did not commit. And they failed Katherine at every single stage of this proceeding. Now, the state wants you to believe that there was no direct link between Sigfredo Garcia and the Adelsons. They say that they have no evidence of this. But as you saw here in this courtroom, throughout the course of this trial, that is completely false. It was the call from Sigfredo Garcia directly to the Adelson family that cracked the case open for them. Literally, the reason they were able to find Garcia is because of the call he made to the Adelsons. They may get up here and try to diminish its significance because it goes directly against their theory. Oh, it's just one call. It's a call. It's there. That's the link. Once they had Garcia and Rivera, and then saw that Katherine had a relationship with Charlie Adelson, they started to build their case around their theory that this must have gone through her. Now, let's be real about what the state is trying to sell you guys. This is where I need you to just apply your common sense. They actually want you to believe that Charles, a brilliant master manipulator, that's how their witnesses described him, decided to ask the girl he was dating for a few months if she could get someone, her ex-boyfriend, to kill a man she never met. That is their theory. Do you really think that Charles Adelson then decided, you know what I'm going to do? I'm going to use my phone to communicate about this murder. That way no one will ever find out. Members of the jury, it's not the 1990s, when cell phones just came out and everybody didn't know what their capabilities of recording your phone calls and your records. It's all there. You remember what Ryan Fitzpatrick told you. He's brilliant. He would never use his phone, as would any with any common sense, to orchestrate a murder. This is someone who Charlie knew for years. This is the one witness that could come in here besides Wendi Adelson, because you can just discredit every single thing that came out of Wendi Adelson's mouth. But Ryan Fitzpatrick came here and told you who the real Charles Adelson is. A manipulator, brilliant, someone that can see something and just work on it quickly. The state keeps harping on this flurry of communications between the parties, even though each one of their witnesses got up there on that witness stand and told you there is nothing unusual about a woman having communications with the guy she was dating and then also talking to the father of her children. Every single one of their witnesses said that, including Agent Sanford, who you could tell for yourself was just not open to anything other than his theory of the case. Let's talk about the call detail records. Sergeant Corbett. I know everybody remembers Sergeant Corbett. You have to love Sergeant Corbett because he is the epitome of an unbiased witness. His job is to interpret records. And even he told you, even though it's not good for their theory, he cannot tell you. He even told you that the communications that they presented to you, they're not complete. We don't have everything. We can only go off of what is in the call detail records, right? What makes it even worse, they then present these summaries to you, only from the call detail records. And what do? They literally get up here and ask you, after they've taken out every other phone number that is on the call detail records and just left the numbers of the people who they think are involved, to rely on that, and that is somehow complete, reliable evidence that this is a flurry of communication of people that are committing a murder. Why is it that the state, who has the job of proving the case beyond all reasonable doubt, the job to show you all of the evidence, is taking out all the other calls from the records and only creating charts that have the names of the people that they believed were involved? That would make anybody look guilty. There are these numbers on Katherine's phone records when they present it to you. You notice when they start putting up, oh look, these are the calls from the June 2nd date. There are all these numbers there that are unaccounted for. They are the Tallahassee Police Department and the FBI. They told you that all they have to do is send a subpoena, and poof, they get the information. They didn't do that. They have Katherine's contact list because they have her phone. But the only names that they take out of her contact list? Luis, Sigfredo, and Jessica, the people that help their case. What is her mother's phone number? What's her brother's phone number? What are her best friend's phone numbers? They didn't even look or try to figure out who are the other people that she was communicating with. Why are they leaving all of those numbers out, members of the jury? We know they can do it. They did it for Wendy's call detail records. Look at the day of the murder. Her list comes up and every single number has a name associated. So you know they can do it. We specifically talked in jury selection about how important it is to investigate each and every lead objectively. And what excuse did you get from the detectives in this case? Both Detective Isom and Agent Sanford with the FBI? Well, I didn't think it was relevant, so I didn't follow up. Everything in this case is filtered down for you, members of the jury. This is what the state is trying to do. Filter out all the facts that do not fit their theory, and then only present you with what they believe is important. Sergeant Corbett looked at you and told you, I cannot tell you that these cell phone tower pings prove that Katherine Magbanua was at a certain location. All he could testify to, well, it's consistent with her being in the area where the tower is located. Now, as much as Ms. Dugan or Ms. Kappelman came up here and said in their questions that Katherine Magbanua, when Katherine Magbanua took Sigfredo Garcia to rent their car, their own expert told you no one can to that. There is zero evidence that proves beyond a reasonable doubt that Katherine Magbanua took Garcia to rent the car. They literally just want to say, well, it can't be a coincidence that she's pinging here in an area where one of her friends lives. And, oh, we also presented the rental agreement. Now, even though there's nothing there that says the time the car was picked up, we want you to rely on, usually it corresponds with the due date. Literally in the rental agreement, there's a slot that says time in. But no. Make the assumption, even though that's blank, that, this guy who came in here, who says he doesn't independently remember anything, I'm sure you know that I would have done it 24 hours before. Everything is inference upon inference, assumption upon assumption, for them to prove even one simple fact. One thing I can tell you, and I'm sure Ms. Kappelman will get up here and tell you, consistent with is not beyond a reasonable doubt. Not even close. Maybe this is what happened. How many times did Ms. Kappelman get up here and say that in her explanation of the case? Well, maybe this is what was said, and probably, and I believe, all of those words are not proof beyond a reasonable doubt. Every piece of circumstance in this case is consistent with Ms. Magbanua having zero idea or any involvement in Dan Markel's murder. Let's start with the Lexus. A 160,000-mile 2001 Lexus that he sold to her. Now, the state wants you to ignore all the evidence that says she bought for it and that she paid it. They have zero evidence that says it was a gift. Think about it. Think about Agent Sanford's reasoning that he gave you for that. Well, there's no corresponding withdrawal from that amount, so that means she never paid for it. There are text messages from the iCloud members of the jury. Mr. DeCoste had out through their witness, Mary Hall, less than 2 weeks before the title transfer. They have text messages from Charlie Adelson's iCloud telling her to transfer the title into her name and that she paid $2,400 for it. It's there in black and white. Not only do they have that, they actually have the title transfer where her signature is on it, Harvey Adelson's signature is on it. That is the definition of what? A paper trail. Why didn't they show that to you? That is what you should be asking members of the jury. This is the state's burden. Why are they not giving you everything? That is a legitimate question. Why is it that they only get to show you the things that they think support their case? The only logical explanation is that it could just be proof of Katie's innocence, just like with the texts about her paying for the car. They are the state of Florida. They're supposed to show you everything. If they were that confident in their case, members of the jury, then why just not let you have everything? It should be very concerning to you that the prosecutors in this case are hiding things from you. Their act of hiding it alone proves that she is innocent. Next, let us talk about the breast augmentation. Now that is just flat out offensive. That both of these female prosecutors would argue that her surgery was payment for a homicide. Zero evidence at all that he paid for anything. She actually even brought up the June Umchinda statement that I don't even know. Oh, I think he may have said he paid for one. That is all they had. That's the evidence that they presented to you. Except that every other person says either Sigfredo paid for it or she paid for it. But let's see what they did. You follow up, right, with records. So they go to her doctor and subpoena her records. And what does it show? That she paid for it. Just because it's cash, it doesn't mean that she didn't pay for it. You heard from Katherine, the girl who was working multiple jobs, a single mother of two, to take care of her kids. And the state actually tried to make it seem like she's a bad person because she did one thing for herself. And we know it's true because Yendra, the state's own witness, told you from day one, she's always wanted them. This is not something that is just a surprise to everybody. Poof, I went and I got breast enhancement surgery. And with all this evidence, they're still asking, ignore that, and just assume that this must be payment for a homicide? Now let's talk about the cash deposits. Okay, first we have her bank records from before she even knew Charles Adelson. She met him in the middle of 2013. Now, mind you, they only went back 6 months. It's not like they got anything past that. But even then, before she met him, she's depositing cash the same way that she does in 2 separate bank accounts. There's nothing unusual about that. She's always been doing that. She works several different jobs that pay cash, including the ultimate cash-making field, the service industry. Anyone, including myself, who has worked in the service industry as a waitress, bartender, anything, knows it's an all-cash business. The state's own witnesses told you that Katie was paid in cash. But no, they spent hours and hours and hours in this trial trying to make it seem that the cash that she got was payment for a murder. Then they have the audacity to come into this courtroom and say, well, you know, there isn't really a record of her getting paid in cash. Oh, there's maybe one. Agent Sanford was told by Indra back in 2016 the name of the 2 clubs, the fact that Yindra actually worked there with her. And what does Agent Sanford do? He doesn't go to the clubs in 2016. That is what an objective agent would do. Let me go and see if this is true. This person that I went and is offering me information about Miss Magbanua tells me that she's working in an industry where she makes cash. And you just don't go and get the records? You literally wait until the worldwide pandemic hits in 2020, after she has already testified once before about everything. That is when Agent Sanford decides, you know what, let's go and check out those clubs. They actually take pictures of the nightclubs during the day, during the pandemic, when everything is shut down. Then Ramsey Neighbor comes in here and says, well, you know, I had records, but there was a hurricane, and in the corner where all the records were, everything, you know, got flooded. And had he gone back in 2016, what would he have been able to get? The records. But no, they come in here 4 years later, because you know what Agent Sanford was trying to do? Because he's probably going to say, oh, you know, they're going to say I didn't look into this. Let me go and look into it now. It's too late. Everything is now gone. Because of you, the records are now lost. Katie never thought, oh my God, I have to gather evidence for myself from back in 2016 and keep records of this because the state is going to falsely accuse me of being involved in a murder. It's the agent's job, members of the jury, and the Tallahassee Police Department. They have the power and the resources to collect this evidence. Not to mention, Katie herself told you, Sigfredo would give her cash whenever he came into some. Why is it okay that Luis Rivera gave his sister money after the murder? She didn't get arrested. Why is it okay that he paid his mother's rent for a year with the money from the murder? She's not in jail. She didn't even come in here and testify. But no, when Katie does that, because the father of her kids gives her money, she's getting paid for a murder. That corresponds right around the time that Charles paid Sigfredo. And what does he do? I'm going to give money to the mother of my kids, who all she does is bombard me with the fact that I don't help her. And then the best part is, what does Katie do? What would someone do with cash that they received from a murder? Let me see what I'm going to do with that so that no one ever sees it. I'm going to walk into the bank and deposit it so that everybody can see it, so that they can pull up all of these records and go, look, here is all her cash. There's 0 records of Charles Adelson withdrawing cash, but they say he's guilty. There's 0 evidence of either Luis Rivera or Sigfredo Garcia depositing their money in the bank. They're guilty. That just shows you that if you know that this money, it doesn't take a rocket scientist, members of the jury. You're not going to deposit it in the bank. She said it. She's a well-educated college woman. There is no, you just put it under your mattress. Why are you going to walk into the bank and deposit money from a homicide so that everybody knows that it's there? Don't you see, members of the jury? Everything she did is actually evidence that she did not know. Depositing the cash into her bank account, putting her name on the card transfer title with the name of Harvey Adelson as well. And then the one that the state actually thinks is evidence for payment of a murder, putting her on the payroll. Really? That's what you want the jury to believe? That Charles Adelson decided, you know what they're never going to find out? They'll never find out that I'm paying Katie for this murder by putting her on the payroll. Common sense alone tells you, members of the jury, that that was not payment for a murder. Yindra told you exactly why Katie asked to be put on the payroll. There is text messages from the iCloud account corresponding exactly to the day when it is that she asked to be put on the payroll. It is there, black and white. And who had to show you those text messages? The people who don't have a burden in this case. The defense. We have, by law, the right to do nothing. We had to get up there and show you this evidence that supports her innocence. Another thing that they are hiding from you, there's no excuse for them not presenting it to you. What is Ms. Kappelman going to come up here and tell you? Well, I didn't think it was relevant. Because that seems to be what the theme is in this investigation. Turning a blind eye because I don't think it's relevant. And then they want you to come in here and say, well, she didn't go into the office, so as far as we can tell, she was working there, in our opinion. It's just ridiculous. Katie herself got up on that witness stand and explained what it is. It's not a legitimate, 9-to-5 job where she goes in. There are text messages that support that she is basically a personal assistant for him. He's doing a favor for her. And this is helping her get the insurance for her kids. Why would Katie get up on the stand and say those things if it wasn't true? 2 years ago, the only person that has been consistent throughout this entire investigation is Katie. They knew about that back in 2019 and still are not able to produce any evidence that says she was not working there. It's, we didn't see it, so it didn't happen. We didn't see the communication, so it didn't happen. That's not how this works, members of the jury. Now, Katie said it best. Just looking at it from one angle, it looks bad. It does. Because when you just kind of look at the surface, you're like, these guys have no connection to these guys, and then, oh, they have one common denominator. But this is because Charles and Sigfredo made sure to keep their communication a secret. So Katie is the one that ends up being the easy way for the police to explain what happened. From this point on, Katie had no chance because she was now considered a suspect. And they zoned in on her and tried to build the case around her. So what do? Let's do an undercover operation so we can stir up some chatter. For one, let's talk about the blinders that the FBI put on while they were conducting this investigation. The bump. They already know that Sigfredo Garcia is involved. There's no question. They have probable cause to believe that he is the murderer at this time. And what do? They don't tap his phone. You know he is the murderer, and you don't tap his phone? I've not heard from one witness on this stand to give any reasonable explanation as to why you wouldn't be monitoring his phone. Willful blindness. Don't let Ms. Kappelman get away with it. Have her get up here. She gets 10 minutes when she comes upon rebuttal and answer that question for you. A good reason. Don't let her give you an excuse. And if she can't give you one, that's reasonable doubt, members of the jury. All you are going to hear are excuses upon excuses upon excuses of why things are missing, and you don't get to see them. Next was the gravest mistake that they made in this case. They planted Katie's name into the investigation. Instead of doing the bump and not mentioning any specific names, and then seeing what happens, they say Katie and Tuto's name. He says it on the call. You can hear it, listen to it. You're going to go back into the jury room and you can play it for yourself. The call from Charles Adelson to Katherine Magbanua. My mom said it had to do with an ex-girlfriend. If it is not you, I'm going to feel stupid. He even says, as soon as I find out what this is, I'm going to tell you what it is. I'll show it to you. Then the very next day, Dolce Vito. Now, members of the jury, I'm not going to stand up here and tell you what I think Charles Adelson is saying in that audio recording. Listen to it for yourselves. When you go back into that jury room, and I am hoping you take this opportunity to remind you again of whose burden it is in this case. It is the state's burden. Because the fact that the state has to present a recording and constantly have to tell you what they think is happening is not proof beyond a reasonable doubt. You saw Ms. Dugan. That was half of her opening statement and half of Ms. Kappelman's closing. Her adding words and making up sentences of what is going on in this conversation, speculating about what is being said and what she thinks Charles Adelson is talking about. Members of the jury, it's not your job to go back into that jury room and try to figure out what is being said. They should give you enough reliable, concrete evidence that there's nothing for you to figure out. That's beyond a reasonable doubt. It's not your job to try and make sense of the nonsense case that they have brought to you. If Ms. Dugan had any confidence in the strength of this piece of evidence, she would say, members of the jury, there'll be no question when you go back into that jury room. You listen to it for yourself. You're going to hear, and there'll be no doubt in your mind that this is what they were talking about and they're conspiring about a cover-up with a murder. No, it's the opposite. Let me tell you what we think is happening there. Why is it that they're desperately trying to shove their interpretation of what is going on in that audio down all of your throats? Number one, just go listen for yourselves, members of the jury. You'll be able to go back there and listen to it for yourself. Why is he telling her that he hopes it's the cops? The state has not, funny enough, out of all the things that they read, they leave that statement out. A statement they have really no logical explanation as to why he would be telling Katie, I hope it's the police. I want it to be the police because I didn't do anything wrong. Remember, members of the jury, in a criminal case, the benefit of the doubt goes to Katherine. When you are evaluating this evidence, the benefit of the doubt, you resolve it in favor of Katherine. She is presumed innocent. You heard it when the judge said it when he was reading the jury instructions. If there is any doubt about being said, you have to resolve it in favor of Katherine. Katherine gets the benefit of the doubt. They have the burden to prove to you beyond a reasonable doubt that they were in a conspiracy together. And not once do you hear Tallahassee, murder, Dan Markel, something definitive so that you know that that is what he is talking about. It speaks more that he doesn't mention it. Because if he did and she had no reaction, that would be strange. She told you, if he had said to me murder, then I would have remembered. But you want to know what is the most telling, members of the jury? Believe it or not, it's Miss Magbanua. Miss Magbanua. Before this enhancement even existed, Katie subjected herself to cross-examination by Miss Kaplan about that very meeting. If she wanted to lie, she would have right then and there. She had all the opportunity. She could have made up all types of things of what it was that he was saying to her, because that's what guilty people do. Instead, she testified to the truth before even knowing what the enhancement was going to produce years later. And there is not one thing in her prior testimony that contradicts what is going on in that Dolce Vita video. Think about that, members of the jury. She testifies before the enhancement even existed, and they can't point to you one piece of evidence in her 4-hour questioning that says that contradicts what she said. She told you. She told them back in 2019. He was talking in circles. Scenario after scenario. I'm trying to follow him. You can see for yourself in the Dolce video. It's just him. Yap, 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 yap. As much as they want you to try and guess what Miss Magbanua is saying, that's not right. You know she's talking. They're asking you, they're the ones that said don't speculate, but they want you to speculate as to what Miss Magbanua is doing and saying. How do you know she didn't say, dude, what are you talking about? Like, what's going on? You don't know that she didn't say that because they weren't able to record her voice. Always the focus of this investigation is getting to Charles, getting to Charles, getting to Charles. But no, don't focus the microphone on Katherine Magbanua. You don't even see her in the picture. And then all we have left after this investigation is a chopped up audio of just him talking at Miss Magbanua. The state is so desperately trying to force their interpretation and view of this case onto you. But that is why you don't rely on them, members of the jury. Half of the things Ms. Dugan said in her cross-examination to Katherine about what Charlie said was flat out incorrect and misleading. Listen for yourselves, members of the jury. It is so obvious that he is doing exactly what Katie said he did years ago, talking in scenarios, trying to convince her to call this number and see if the guys will take the money. He keeps saying it's because they said your name. He's instructing her on what she should say, all the while reassuring her that he has done nothing wrong. Simply put, this is not the conversation that would be had between co-conspirators to a homicide. All it proves is that she had no idea what was going on. And then to add insult to injury, they don't record all of the phone taps after the bump. They don't. Oh, we had officers, they were monitoring and taking notes. Once again, we have to rely on officers' determination of what they think is relevant and what they should recall. Why didn't they get the call detail records from the time of the bump? We have to get them for you. When you go back into the jury room, take a look. There's a clip from the day of the bump that we got from AT&T of Charles Adelson's records. There are 3 unexplained phone calls after the bump. Now, I know Ms. Kappelman tried to get up here and say, oh, Agent Sanford, who wasn't listening to the calls himself. What was that about? Oh, I think it was about work. Why not play it for you? Why not come in here and say, listen to all the calls? That is giving you all the evidence, members of the jury, so that you can sit and listen for yourselves instead of just viewing the things that they want you to see. We are here having to rely on what officers believe is important in this complex case, or what they think is relevant. Because one thing I can tell you that I have learned from being involved in this trial, you cannot rely on someone else's interpretation of what is being said on a recording. Miss Dugan is the prime example of that when it comes to her masterful misinterpretation of what is being said on the Dolce Vita video. But that's all they are giving you as evidence, members of the jury. And on top of them not recording everything, they don't want to give you all of the phone calls. What is going on here? It's their wiretaps. It's their evidence. You saw the list of how many calls there were and the select few that they decided to play for you. Now, I'm sure she's going to come up here and say, oh, members of the jury, it's so much, and we just gave you what we thought was relevant. How is that objective, members of the jury? And just to show you how unreliable this method of surveillance is, look no further than the wiretap between Sigfredo and Katie. Remember that one? Miss Kappelman spoke about it, where she's saying, you don't tell me anything, Tuto, and he says, I'm not making that phone call. That phone call is minimized. You hear it when it goes, and then it picks back up again. Who in their right mind, who knows anything about this case, determines that's the call I'm going to minimize? They say that they're talking about the number. They're actually talking about what they believe is evidence of them having, and you minimize that call, that's lost forever. We will never know what was said on that phone call. And one thing I know that is clear to this day, Sigfredo tells Casey, one thing that's clear, thank God they turned it back on in time. The less you know, the better. Sigfredo Garcia is telling Katherine Magbanua, the less you know, the better. Why would he be saying that to the mastermind middle person of the conspiracy? That's what they call her. And what is even more concerning is that the state is actively trying to present some of the recordings to you. That should be another concern for reasonable doubt, members of the jury. For what other reason would it be than because these calls don't fit their theory? The fact that they did not want you to have all the recordings in and of itself is reasonable doubt. And the most interesting part is they had their pick of the litter. They got to choose out of these 400 recordings what they thought would be beneficial to their case. And that's what they came up with? Out of all 400 recordings, those recordings don't prove a thing. It proves that Katherine has no idea what's going on and that she's trying to do a favor for Charlie because that's all he does. She's probably trying to do it just like how Ryan Fitzpatrick said, just to shut him up. He said, that's why I stopped being friends with him, because I just can't. He even said, Charles Adelson, it was such a great description, will say things over and over and over again, 100 different ways, 100 different times until you basically just give up and go, okay. That's probably why she said to him, yes, I'll call, and then doesn't call. If they're all in cahoots together, why is she lying to him? If she's really worried about what is going on here, that this might be the police, why is she lying to Charlie? So what, now they're not in a conspiracy? So they're in a conspiracy when it works for the state, but not in a conspiracy when it doesn't fit the evidence and what the recordings say? They cannot have it both ways, members of the jury. The only thing those recordings showed you is how guilty Charlie and Donna is. And where's Donna Adelson? At home in her living room, probably watching us right now, live stream on that camera. She hasn't been arrested. I knew Miss Kappelman would get up here and say, oh, don't worry about that. That's for a different day. And no, you can consider that. They come in here and tell you that they're going to prove to you without a reasonable doubt that these people are involved and that they conspire. And the only one of them that's in jail is Charles Adelson for the past month, like they just did it. Wendi Adelson, they actually brought her in here, members of the jury, and gave her immunity. You saw that horrible performance that she put on that witness stand. I mean, the fact alone that she even got up here and in her own way treated herself like she was a victim. She's there throwing in little jabs. Oh, well, you know, if he cared as much about me as he did. Like she's disparaging Dan Markel, her ex-husband that's been murdered. And then has the audacity to come in here and defend her family. You heard the testimony from Jeffrey Lacoste. I know you all heard that. I brought it out. There's more evidence against Wendi Adelson than there is against Katherine Magbanua, and they give her immunity. There is no question that those recordings had nothing on them. You want to know why? If there was anything on those recordings, anything at all that was direct, reliable evidence, they would have put her in handcuffs immediately. And Charles too, back in 2016. Instead, what do? They release a probable cause affidavit unsigned, basically saying this is all speculation. We can't arrest them now. I thought they said that these recordings prove that she's involved in this murder, but it's not enough to even arrest her. Probable cause is down here. Beyond a reasonable doubt is up here. And then even though they're releasing this and they're still monitoring Katie's phone, okay? They don't play any of that. You know when they brought Detective Isom in here and they kept going on about, oh, we came to her house and we were trying to give her an opportunity. No, no, no. You showed up there unannounced, car parked down the street, no marked units in her house, you don't identify yourself and you start banging on the door. There's a recording, they testified to it, of what Katherine was saying. They don't want to play it to you. Why don't they want to play it for you? So there could be no question about what's going on in her mind. We tried to introduce some of the calls, but we couldn't. So they got to pick what they wanted to play. Keep that in mind when you go back there. What is on those other recordings? Because you best believe.
I'm going to object at asking the jurors to speculate about items not in evidence.
Overruled.
Because that's actually part of the instruction, members of the jury. The lack of evidence in the case can also be the reason that you find reasonable doubt. Then on May 25th, this is where they thought that they were going to, okay, we'll get her now, all right? We're still listening to her phone. May 25th, let's go and arrest Sigfredo. But the only thing we're going to release to the media is that Sigfredo Garcia was arrested for the murder of Dan Markel up in Tallahassee. They're still listening to Katie's phone calls. They haven't released a warrant, so no one should know that their phones are being tapped. And members of the jury, if she was part of this conspiracy and he gets arrested for the murder in Tallahassee, you don't think that there would have been something on those phone calls? Anything of cause of concern? Not her just crying and saying, I don't know what happened? That's not the conversations of someone in the know. And let me tell you, the fact that you don't have them alone lets you know that it doesn't fit their theory. Because if there was something on there, they would have played it for you. They're continuing monitoring our phone until June 3rd. And then after that is when the government decides, okay, we're trying all these things. We're doing this covert operation. Wiretaps are meant to catch people saying something incriminating. 400 recordings and nothing direct that says she's involved in a harm. 400. And they didn't record everything. Okay, so that didn't work. Let's go and arrest Sigfredo and see if she says anything. That doesn't work. All right, we're going to use the media as an investigative tool to try and obtain evidence of guilt against Miss Magbanua, never giving her the benefit of the doubt, never treating her like every other person in this case. You heard Junum Chinja. She was dating Charlie. How come they went to her apartment, identified themselves, sat there and waited on her, said, oh, we'd like to talk to you, and treated her nice? Everyone else got that treatment. Jessica Rodriguez. Hey, listen, we need to get some information from you. Let's talk to you. Yindra. Everybody. Katie, you go to her house, bang on her door, don't identify yourself, and then she never hears from you again. That's giving her a chance. That's treating her like a witness, not a suspect. And that's the problem. They treated her as a suspect from day one. That is why they were so blind to all of the evidence that proved that she did not know. They released a 19-plus page report detailing how they believe Miss Magbanua is the middle person. Just like Luis Rivera said, the mastermind. And as much as Ms. Kappelman tried to mislead you into saying that she fled, you heard it yourself, members of the jury. We, the ones who have no burden, had to call back Detective Isom to the stand so that you could get the whole truth and nothing but the truth. What was that about? You're going to get up here and then on redirect? Oh, yes, she tried to flee. She knows better. Has all of the evidence. And then she literally comes to you and says, she fled to her brother's house and we didn't know where she was going. I thought you guys were watching her every move. Pole camera here. You have her phone. She didn't dump her phone. Go check her pings. She's right about her brother's house. Wouldn't that be the next logical place to look? But no, she never gets the benefit of the doubt. The state actually tried to argue that that was evidence of guilt, that she fled. But it's the opposite, members of the jury. She stayed in Miami. Even after they went on the media with a 2020 episode for the entire nation to watch, accusing her of being involved in this. And she stayed. And you know what's part of it too, members of the jury? When you know you're innocent, you have this faith in the justice system. You believe, you have this feeling that our justice system doesn't do that. It's designed and built in a way that innocent people will not be punished for things that they didn't do. So she had that faith in the beginning. Okay, yeah, I know they're saying all this stuff, but I know I'm innocent. So there's no reason for me to run. And then what happens? The state becomes even more desperate. This is when they become desperate, is when their objectivity becomes cloudy. Because they turn to the worst person, the most desperate person, to help with their investigation. Now remember the timeline of how they got his statement, members of the jury, because it is very important. They meet with him in August of 2016 in a very weird way. Jason Newland, who we had to call to the witness stand, and Miss Kappelman, is in one room, and Luis Rivera is in another room with his lawyers. And they're just asking questions back and forth. Oh, send a message over here, and then we'll send a message over here. That was all designed in a way to what effectively happened. No one has any idea about what was said in that meeting. Your first meeting of getting any information from Luis Rivera, the suspected murderer in this case, and you don't even take notes? Jason Newland comes up here, he's an investigator with the state attorney's office, and tells you, I don't remember what happened. I just remember it didn't resolve in a plea. I think it had to do with the sentencing. What excuse is there for not writing down what he said? There's no excuse. Then September 30th, it's a month later, 2 months later. It's the day before Katie gets arrested. The detectives hear, oh, he's now cooperating. Go and take his proffer, his statement. And what do they do, members of the jury? It's inexcusable. We don't record proffers. I think one of them just said we don't do it, and someone else said the state attorneys told us not to record it. I still haven't heard a logical, reasonable explanation as to why you wouldn't record that first interview of Luis Rivera, other than you don't want to record his mistakes. Don't listen to the excuses about policy and, oh, we don't do that. It's an excuse. There is no, the jail was equipped. The video you saw of the October 4th recorded statement is in the same jail that they met with him on September 30th. No excuses. They could have recorded it. But this was his dress rehearsal, members of the jury. And Detective Isom even told you himself when Mr. DaCosta was questioning him. But you said this, and you said, well, that's how I interpreted what he said. Why does everything have to go through the filter of these police officers? We wouldn't be sitting here if they recorded everything and you could see it for yourself. Because that's what I'd say. Members of the jury, I don't even need to say anything to you. Watch it for yourself. But no, they don't want you. They don't want to make a record of all the mistakes that he made. And even with that, even with his practice session, he couldn't keep it right. Now, I think this is a great spot to just dig into Luis Rivera. Because even without the recording, I think there's no question here. He's a liar. He's a liar. It's offensive that the state of Florida brought that man into this courtroom and is going to ask you with a straight face to find him credible. I don't even know where to begin with the inconsistencies in his testimony. I don't care if he's been asked about this 10 times. You still can't get it right. It's difficult to remember a lie, members of the jury. But the truth, that remains the same. And no matter what he says or how many times they say it, they're actually going to tell you, she said it. His only job was to tell the truth. Whose truth? Their truth? Because it's obvious he is not telling you the truth. Rivera, the judge just read you the jury instructions about cooperating witnesses, and that is some very strong language. Rivera, the man who was facing the death penalty for the murder of Dan Markel, got 19 years to run alongside the 12 years he was already serving. So that's an additional 7 years. And members of the jury, he's going to get gain time for that. So it's less than 7 years. He might be out this decade. Now, I know Ms. Kappelman kept asking all the witnesses, oh, did you tell him what to say? And they said no. No one is saying that the detectives or the state said, here is a script, I need you to say exactly this, right? Because hopefully it would have been much better than that. That's not what we're saying that they did. What we're saying is that they left the crumbs there for him to pick up. It wasn't an objective investigation. From day one, we had to play a recording from you of Pat Sanford, all the way back in June, when they first met. And he says to him, we know Katie is the one in the middle doing everything. Why would you say that? We don't need Garcia. We already have him. You don't think Rivera's like, bing, okay, I know exactly what it is that you guys want from me. You only want Katie. Then Luis has his discovery. It's obvious he didn't study it, because even with the discovery, he can't get it right. Luis, the guy who told you that he is the man that takes the deal and runs, the convicted Latin King gang member since he was 15 years old. That is who they are actually going to ask you to trust and find credible. Now, the law says something different, and this is what I want you to look at. This is in the jury instructions. When you are evaluating the credibility of the witnesses in this case. Number one, did the witness seem to have an opportunity to see and know the things to which he testified? Check. Did the witness seem to have an accurate memory? Not so much. Was the witness honest and straightforward in answering questions? Absolutely not. Even in the courtroom, he couldn't keep his story straight. Every time Mr. DeCose confronted him with something, he changed his story. Oh, would it surprise you if I told you that this and this? Yes, it would surprise me, because we've spoken to you 10 times and you've never said it before. So yes, it would be a surprise. Did the witness have some interest in how the case would be decided? You're going to kill me, and if I say this, I get 19 years, so I get to go home to Jessica and my other baby mama and all my kids. Okay. Does the witness's testimony agree with the other testimony and evidence in this case? Absolutely not. He couldn't even get the fact that he drove on the first trip right. You remember when Mr. DeCose confronted him with the traffic ticket? Oh no, Garcia drove the whole way up. Wait, hold on, let me show you something. Look at that. You're driving. You know what happened? We pulled over and switched seats. Forgot to tell you that. Right in front of you, that's the excuse that he came up with. That's how comfortable he is. He's like, as long as it doesn't matter what comes out of my mouth, because at the end of the day, as long as he keeps coming here and saying the bare minimum, he's going to get his deal. Well, has the witness been offered or received money, preferred treatment? He's in the feds on a state sentence. Has any pressure or threat been used against the witness? What's interesting is Mr. Rivera himself told you that all of a sudden now, even though he claims this has nothing to do with the Latin Kings, they're all trying to kill him. Oh, I'm in danger, I'm in threat, poor me. And that somehow anybody in this courtroom should feel sorry for him. But he is feeling that pressure. Did the witness at some time make a statement that is inconsistent with the testimony he or she gave in court? I mean, I don't even need to go through all of that. Has the witness been convicted of a felony? 10 times. It's actually there in the jury instructions. Does the witness have a general reputation for dishonesty? Jessica Rodriguez said it. She knows him. He's a lifelong Latin King gang member. His existence and job is to lie and just to get what's good for him. He cares about nobody else. Just a couple things he couldn't get right, which are things that you should know. 2 guns or 1 gun? Don't know. 1 trip? 2 trips? Now, 3 trips. He came into, oh yeah, there was a 3rd trip. I told Jason Newland and Isom that. No, you didn't. Because they testified and never said anything about that. Now, with respect to the phone call that Garcia makes to Katie, telling her it's done, and he claims that he hears her say, I know. Members of the jury, there's no way that Katie would have known at that time. Zero possibility. Remember, their whole thing is we have all the records. Oh, Charles and Sigfredo couldn't be communicating because we can't see it there. So it didn't happen because we can't see it. They have all of Wendi Adelson's records. They showed you. She even tried to present it. Mr. DeCoste caught her. Look at the time that Wendi Adelson drives over to Trescott. The call's already happened. So if they were trying to insinuate that maybe Wendi found out and that she told someone and then that somehow that trickled down to Wendi, if that happened, members of the jury, with their summaries and their charts and their flow charts, you would have seen it. They would have done a nice little cute slideshow for you and put it up here of how that information would have traveled to Katie. It's not there. It's because Luis Rivera is lying. It is impossible that she would have known about the shooting. There's nothing there to suggest. There's no calls to Charles Adelson. They have all of Wendy's phone records. They have all of Charles' phone records, including his iCloud. That is how you know that he is lying. And she still gets up here and is asking you to take that as evidence and to believe Luis Rivera. He's lying, members of the jury. And we also know that even the state doesn't believe Mr. Rivera. Look at how many times he tried to give them Wendi Adelson. He knew that's who they wanted. He actually testified that he saw her on the street with 2 boys the day before the murder. He said, I saw them walk into the house. Impossible. They have Wendy's records. And the boys were in daycare at the time that he said that this took place. If they believed Rivera in any way, shape, or form, why hasn't Wendi been arrested? That's proof that he said, oh, she's here to make sure we're up here doing the job. Why is she not in jail? So he's lying about that. But no. Believe him whenever he presents you with any evidence that's supposed to prove Katie is guilty. It doesn't work that way, members of the jury. How can you trust anything that comes out of his mouth? If you believe him, go and arrest her instead of having her come in here under a guise of immunity to sit down and lie in front of you, because that's what she did. The only thing, believe it or not, that Rivera even managed to write were the details of the shooting. Like the fact that Dan Markel's window was up when he was shot, or the fact that he put his hand up, or that he was on the phone. I thought he was sitting in the driver's seat. Look at the picture that they have from the garage with the door open. It's from the back of the garage. You can't see anything. How does he know that? If he's what are they going to say? Oh, Garcia came in and said, hey, listen, the windows were up, and he was on the phone. And no, we all know what that means. Why do you think he was so quick to jump at the deal first? Let me get in there quick, say that he's a shooter, and I'm going to get my deal. It doesn't really matter, though. They're both guilty, Sigfredo and Luis. Whether they're both in the car, it doesn't matter who shot. But just to let you know the type of person that Luis Rivera is. Those are the things that he gets right, because that is something that he saw for himself. Don't you see what is happening here, Katie? Members of the jury. What the plan was, Luis was to give us Katie, Katie will give us Charlie, and there we go. It would work. And that would have worked, members of the jury, if she were guilty. You heard it from Katie herself from the day that she was arrested. This is why Detective Isom and Agent Sanford came down to Miami the day after they were with Luis Rivera all day. They wanted her to cooperate. This is why Isom would not give me the warrant. And then to top it off, he lies to you about it. Why do you think we had to call Sherry Bennett to the stand? Because she's the one that got the warrant signed. And what did she tell you she did? She emailed it to Detective Isom. Why is Detective Isom not giving Catherine's lawyer a copy of the warrant? I'm her lawyer. And then he lies to you and says, oh, I couldn't give it to her. I have email. Oh, I didn't have a hard copy. You can email it to me. Excuses, excuses, excuses. And worse, you've got one officer saying something that contradicts what Detective Isom is saying. All I had when I went and met with her was the information that Rivera was cooperating. Members of the jury, if she were guilty, she would have cooperated that night. She was already in handcuffs, in Broward lockup. Your lawyer comes to you and goes, hey, listen, all I know is Rivera is cooperating. If she knew about this and knew that Rivera was cooperating and was in the middle, she'd be like, okay, what would you like me to tell you? Do I get to go home? All right. We know how desperately they wanted Charlie. But they've refused to even think or contemplate the possibility that she didn't know. There is no reasonable explanation at all why she wouldn't cooperate immediately if she were guilty. If not then, why not every day for the past 6 years? It's because cooperate to them means to tell their truth. Both Sanford and Newland said it. Cooperate means to tell us the truth. But who determines what that truth is? And what is not? They do. And you know how we know this? Because Ms. Kappelman told you, she sat down with Ms. Magbanua in the jail. Invitation by the defense. Any lawyer will tell you that never happens. That you're going to let the prosecutors, under no promise of immunity, nothing. That's how confident we were that she was innocent. We have nothing to hide. Come and talk to her. And then Ms. Kappelman has the audacity to come up here and say, that meeting was a joke. Why? Because she didn't say what you wanted her to say? She's been in jail all this time, and it was a joke? It wasn't a joke to Ms. Magbanua. None of this is a joke. And for her to get up here and to minimize what that was, and then actually argue to you that that was somehow some defense strategy, that I would somehow know that Ms. Kappelman would go, oh, I think your client's lying, so I can use this in the future as some form of argument. Like I knew that we would be sitting here in this courtroom years later. It's a ridiculous argument to make that that was somehow planned so that we could use it in the future. That makes no sense. She could have sat there and not said a word. They didn't even have to come over, but no. Come over. That's how confident I am, and I will tell you everything. She's spoken to them now 3 times, members of the jury. 3 times. And unlike Rivera, nothing in her testimony has changed. Nothing. Have they brought out to you any piece of evidence that says, hey, listen, she said this one time and it doesn't fit here? Not one. You want to know what the inconsistency is? When someone tells you that they're in Tallahassee, they take a picture of an owl and put it on their Instagram and then come back later and goes, you know what the picture was of? A lion. He literally sat here and said, oh yeah, I took a picture of a lion in the middle of Tallahassee and posted that on Instagram. You notice Ms. Kappelman completely let that out when she was talking to you about the Instagram post. Now all of a sudden it's an Instagram post. Not the fact that he couldn't even get the animal right. They're not even in the same, he couldn't even pick another bird. He went lion. The only person from day one that's been consistent is Katie. And you learned throughout the course of this trial that Katie not only waived that right once, but twice, and now 3 times. We all discussed how important it was, members of the jury. We talked about this at length, about why people don't take the stand, and how you can't use that against them. And one of the main things you saw, how nervous she was when she first started testifying. All eyes on her. And she said it to you herself. I know everyone is hanging on everything that comes out of my mouth. My life depends on this. That is why she sits there and she wants to remember. But they're asking her about text messages and things that happened so many years ago. She had nothing to, this is why she can't remember. Her entire life has just been there for the entire world to see. Who she was sleeping with, all out there. The state making these arguments about how she's a bad person for getting birth surgery for the world to see, and then she elects to do it again. And she told you herself, she didn't have to get up there. She did not have to get there, especially after that Luis Rivera performance. But she wanted you to hear it out of her mouth. I had nothing to do with the murder of Dan Markel. Now, no matter how much Miss Dugan tried to bully her, because that's what that was, members of the jury. Why asking her the same question over and over and over again? Like, she didn't even change it up. The same question over and over, expecting a different response. They thought that that was what, effective cross-examination? What they thought that she'd eventually just wear down and just say, oh, okay? Getting frustrated with Katie when she wouldn't agree with her misinterpretation of the evidence, because that's what she did. She tried to get Miss Magbanua to commit to what she believes Charles Adelson was saying. She even went so far at one point, I know you all saw it, to misrepresent Katie's prior testimony. You saw me fly out of my seat and say, that is not what she said. She did it twice. Now, I'm not sure if she thought we wouldn't catch it. She literally misread Catherine's words to you. That is how desperate they are, members of the jury, to try and piece together this nonsense of a theory to try and sell to you that this is evidence of guilt of Miss Magbanua. It's not right, members of the jury, what they're doing. It's not. As a prosecutors, they should not be trying to skew things for you. They have a different obligation of presenting the evidence to you, all of the evidence. Why are they tailoring it and leaving things out to fit their theory? That's not how this is supposed to go. And another thing, if Katie wanted to lie, she had every opportunity to do so back in 2019. She could have been like Luis Rivera. Oh no, I remember the exact day Sigfredo Garcia brought me money on July 19th, 2018. That day. She could have sat up there and said it. All the evidence is up there that said it happened that day. But she didn't lie to you. She didn't. I don't remember what day it was. That's an honest answer, members of the jury. Her life is on the line and she could have just peppered in all of these little facts. She doesn't remember because she's been sitting in a jail cell for 6 years. She told you herself she had COVID twice. And she still has to get up here and try to remember things that happened in 2014. Now, in opening statement, I told you, and the state, I told them as well, exactly what happened in this case. And it's right there in the evidence, members of the jury. We are the ones that had to bring it to you. The defense had to put the pieces together. The state is the one that is to give you enough pieces of credible evidence to create a picture of what happened so that you can see it clearly. What they have done is picked out what pieces they think fit their theory, throw it into a pile and said, you guys go back there and try to put the pieces together and figure it out. That is not how the criminal justice system works. That is not beyond a reasonable doubt. The state has to give you enough evidence, reliable, credible evidence, so that when you guys go back there, you can confidently say, yes, she did this. That's what proof beyond a reasonable doubt is. And they have failed miserably. And it's because what they think happened is so wrong. The pieces don't fit. June herself told you that when Katie was arrested, Charles said they got it wrong. Just talking about her. That's why he was so shocked and surprised. Like, how could she get arrested? Because he knew she had nothing to do with it. So what supports what we told you happened in this case? We all agree that Charles Adelson is the one behind the murder of Dan Markel, and that Sigfredo and Luis committed the murder. We know that Sigfredo Garcia was actively following Katie when she was dating Charlie. That did not just come out of Katie's mouth, that also came out of all of the state's witnesses. Ryan Fitzpatrick, Yindra Velasquez, Jessica Rodriguez, every single one of their witnesses said that this is what Sigfredo Garcia would do. And it just so happens that the night they met was the night with the dinner with Jeffrey Lacasse. Jeffrey told you he was having dinner with Wendi and Katie and outside. Now, Ms. Kappelman wants you to believe that when Luis Rivera says, oh, yeah, I was with him one time when he tried to run him over, He said that was in Brickell. For any of you who are not from Miami, Brickell is a whole different place than South Beach. That's just a different occasion of when Sigfredo Garcia, that's how much he would follow her, members of the jury. But on this night, they were sitting outside. It's right there in the text messages that he was watching her. Look at that, members of the jury. This is a text from Katie to Charles Adelson. The next day, I don't know, he called me and said, have a nice dinner, and to never call him again. I'm like, WTF. It's obvious, because this is Charles Adelson's iCloud, so you can't assume that she's responding to anybody else but Charles. Why is Charles Adelson asking Katie the next day about Sigfredo? It's obvious that that's who he's talking about. Why is he asking her that? He's trying to see if Garcia told Katie anything about their meeting. And that response let him know, nope, he never told her. So now he was in the clear. Then a month later, you see evidence again that they were communicating. Now, just because the state wants to be able to say, hey, let me give you a call detail record so I can show you flurries of communications between Charles Adelson and Sigfredo Garcia, because of course they'd use their regular phones to commit a murder, right? A month later, Katie to Sigfredo, to Charlie, did Tuto call your phone? He then responds, no. Then, actually he did. He invited me to go deep sea fishing. He was so nice. Now we all know he's being sarcastic. But you see the reference he uses when he's talking about Sigfredo Garcia? Deep sea fishing? Really? We all know what that means. Mob terms. Send them to the fishes. That's how narcissistic Charles Adelson is. That's the joke he decides to, I admit, he's being sarcastic. But that's his little way of putting in there, we're going deep sea fishing. What does Katie say? I'm serious. He's driving me crazy. Is your cell phone online? Why would she ask him that? Other than she's going through Sigfredo's phone and sees Charles Adelson's phone number in there. That is the only logical explanation. Is your cell phone number online? Did Tuto call your phone? She didn't say, is your work number online? Is your cell phone number online? And he goes, no. She was going through his phone and saw that. But then, of course, what does Charles do? He lies to her. No. So, okay, my worry is gone. She was probably thinking, oh my God, why is Charlie's number in Sigfredo's phone? But what do these men always do when it comes to Katie? They just shut her up. I don't know what you're talking about. No, that didn't happen. And she didn't go any further. Well, the state didn't introduce all of the iCloud, but we were able to show you these. Then Luis Rivera makes a trip up here in June. And I only say that because there literally is nothing that puts Garcia on the trip in June. Nothing. Oh, we didn't happen to get the cell phone records for Sigfredo. Really? No records from the hotel? You got the hotel records from the second trip. Luis Rivera, Budget Inn, 2 people staying there. But he supposedly stayed at the Budget Inn on the first trip. You didn't get no records? What excuse did you get again? Oh, we were digging through an attic of paperwork and couldn't find it. Excuses. Then they mentioned something about a drug dealer saw him here. Did a drug dealer, besides Luis Rivera, testify in this courtroom? No. And the murder doesn't happen in June. Charles had all intentions of breaking up with her. You will see in the text messages, members of the jury, when Charles says to his friend, Sully, they're going on a trip to the Keys. This is in June. This is the goodbye tour. He was going to start breaking up with Katie, assuming that the murder was going to go down. That is why Garcia was so mad when he saw them together on July 1st. It's a couple weeks later that Dan Markel is murdered in cold blood in his driveway. And then what's even more telling, members of the jury, just like that, right after the murder, the communications are no longer romantic. I just want to be friends. You really gonna break up with the girl or that you just conspired to commit murder with? There's not one thing in his text messages, nothing, that supports. They have all of his text messages from the day of the murder, the day after the murder, the day before the murder. They don't show that to you because there's nothing in there that shows that she knew anything about the homicide. In fact, the conversations are just so obscure that that's not the conversation that people would be having knowing that a homicide is going to take place. Now, they also make this big deal about how, oh, look, the cell phone towers say that, oh, she's driving up to Yindra and she's going to drop off the kids because she needs to go what? If she was planning this murder and knew it was going to happen, you don't think she would have made plans to have someone else watch the kids way in advance? I'm just going to wait on the night of and try to get Yindra to watch the kids then? That is the planning that's taking place in this homicide? That she has to get the day of the murder Yindra to watch her kids? And she told you. He told me that his brother was in a car accident. She doesn't even remember him saying that because that was just nothing. But what does he tell June and everybody else? My ex-brother-in-law was murdered. He never says that to her. Never. And let's not forget the day after the murder, because they are trying to paint this picture that Katie came and delivered money for the murder from Charles to the hitman. First you hear, first of all, the only evidence to that is Jessica Rodriguez and Luis Rivera. They can't get their story straight. As much as they tried, as much prepping that probably went on, even they couldn't get their story straight. Luis, I was at the barbershop when Jessica called me. The records directly contradict that version of events. He actually tried to get on the stand and for the first time say to you, oh, I gave Anthony Ortiz my phone. That's why I'm pinging down here. That's the first time he's ever said that. Do you see what happens when you confront him with something that contradicts what he's saying? He just on the fly tries to fix it. And then I thought Ms. Kappelman just got up here and said that number is Jessica Rodriguez's number. Isn't it Anthony Ortiz's number? Whose number is it? They actually put up the demonstrative and it still says Anthony Ortiz. But she comes up here and goes, well, it's saved as Jessica. Whose phone number is that? They're supposed to prove to you and have those questions all resolved. But no, it's okay, members of the jury. Just, this person says it's this number and this person. We still don't know whose number that is. And if you believe Luis Rivera, that was Hibaro or Anthony Ortiz, you don't get those phone records to see if maybe he was with Luis Rivera on the first trip? You don't get those phone records to see if maybe there's some... It's willful blindness, members of the jury. That number is actively in the midst of their flurry of communications. And you don't get the phone records? And then, Jessica Rodriguez. First of all, Miss, I want nothing more to do with this case. I wonder why. I'm not even going to waste too much time on her, because that nonsense that she came in here with, you heard what she said to Luis in that email back in June, the same day that the cops came to speak to her. No matter what, from this point forward, I will do what I can to make sure you come home. You keep that crown on your head. That's what she says to him. After she just lied to Sherry Bennett, or whoever it was that came and interviewed her in June. I don't know anything about anything, nothing to do with Kututo and Katie and none of that. But then what happens when Luis Rivera needs someone to back up his story so that he can get his 19-year deal? Oh, I remember this time when they came to my house. Now, they're going to try their best to try and pigeonhole it to the 19th. Oh, she said 1 month, she said August and September. We played it for you. She's got the days wrong. Then she's all over the place. Oh, I thought it was a brick. You heard what Ryan Fitzpatrick said about the money. It's $100,000. All in hundreds. That's what Luis Rivera said. Stapled. That's not a brick. Okay? That's not a brick of cocaine. And then she, on top of that, says, completely different from what Luis Rivera says, oh, I asked her if what was in the bag. I don't know. but then now wants to come in here and change her story again and say something different than what she said before. That is what they brought to you, members of the jury. That is what they brought to you as direct evidence to try and prove that Katie was involved. But no matter how hard they tried, there is not one piece of credible evidence, reliable evidence, that was presented to you as jurors that would allow you to go back into that jury room and say confidently that this is what happened. The only evidence was Luis Rivera, and he is a walking contradiction. Look at what the law says you must consider in this case. Oh no, I think I already have. That's all right. The law also spells out for you where reasonable doubt comes from. It comes from the evidence itself, the lack of evidence, and the conflicts in the evidence. Members of the jury, their case, their theory is littered with all three. Their theory in this case conflicts with reason and common sense. That is reasonable doubt. And then the one major concern that you should have is that the state is actively withholding evidence from you. That should always be a question in your mind, members of the jury. Why? We, by the letter of the law, do not have a burden of proof. We do not have a burden of proof. But that chart, actively reflects what the burden of proof is in this case and what beyond a reasonable doubt really means. When my team actually gets it up, it will not just leave it up there, okay? But this is the truth. This is what it is. This is all not guilty, members of the jury. Maybe something happened. Suppose, I believe, all of that is not beyond a reason. Probably guilty, not beyond a reasonable doubt. Likely guilty, not beyond a reasonable doubt. All the way up there, that's how high the burden is. You cannot go back into that jury room and say, I think this is what happened, or I believe this is what happened. Not in a criminal case when someone's liberty is on the line. Now remember, Ms. Kappelman gets to get back up here and do a rebuttal. And I'm going to challenge her right now, because I don't get to come back up again. I want her to come up here and present you with one piece, just one piece of solid, reliable evidence. In this case, that doesn't require her interpretation, her speculation, her inference. Something that's just not a coincidence, or maybe this does not happen. Something that isn't, this is consistent with. And she's not going to be able to come up here and present you with one piece in this mountain of evidence that has been introduced in this case. That is evidence that is proof beyond a reasonable doubt that she knew. I challenge her to come up here, point to one thing, and show it to you. And if she comes up again and does not show that to you, and just ignores my question and ignores that alone, members of the jury, lets you know that she's got nothing. She's going to come up here and try to give you the runaround, and how they wish they could get better evidence, and how I don't get to pick my witnesses, and it's not my fault. That's a not guilty. One piece of direct evidence that is not Luis Rivera. Something that is not. They have hundreds of thousands of text messages, 400 plus recordings. When have you ever seen an investigation of this magnitude that didn't yield something direct? Look at the evidence against Luis Rivera and Sigfredo Garcia. That's evidence beyond a reasonable doubt. There's no question that they were up there and that they went upon that trip. The Prius, I could even make an argument, but no, they shut that down because of the unique characteristics on the Prius. That's what separates that Prius from any other Prius in Miami-Dade. Every possible reason that you could have tried to explain to say maybe it's not them, they covered their bases. I'll give them that. That's proof beyond a reasonable doubt. And remember, they're charged as a principal. So it doesn't matter which one of them shot Dan Markel. Okay? So that is proof beyond a reasonable doubt. They have nowhere near brought you anything close to that where you can say, yes, Ms. Magbanua had something to do with it. And that's because she is innocent. That's why, members of the jury, that evidence doesn't exist because she is not guilty. That is how Ms. Magbanua sits here today living the worst nightmare that anyone on this planet could imagine. Sitting in a jail for a crime you did not commit. Knowing all the while that all you have to do to go home is lie. I'm involved and Charlie got me to do this. She got up there and told you herself, I believe he's guilty. I want him to pay for what he did to Dan Markel and also for getting me involved in this nonsense. And all she'd have to do is lie, members of the jury. That's it. But she's not Luis Rivera. No matter what she did, she has stuck to the truth every single time. And she's not going to sink to his level just to buy her freedom. This is another question that Ms. Kappelman, when she gets back up here, is not going to be able to answer you. Why in the world would Katherine not cooperate if she were guilty? Why? She's going to come up here and speculate, maybe this and that. She told you you can't use speculation. What evidence can she show you to say is a legitimate reason why? If she knows that's all they want, if she were guilty, why wouldn't she take the deal? Why? She's going to sit in jail and take her chances on a first-degree murder case with 2 other first-degree solicitation and conspiracy charges? You heard Luis Rivera that he was facing the death penalty on one of those charges. I'm not saying she was, but that's just to show you the level of severity that she is facing. And all she would have to do is just say, yeah, I'm going to tell you your truth, and she could go home. But she's not Luis Rivera. If she does not come up here, Ms. Kappelman, and give you that explanation, something reasonable, something that's based on evidence, it's not guilty, members of the jury. Because there's no reasonable explanation why a guilty person wouldn't take that deal. That is evidence of her innocence. And members of the jury, please, I beg of you, remember that oath that you took at the beginning of this case. The promise you made to look at the evidence in this case objectively. That's what we've been waiting on. We need objectivity. I told you, and so did the judge, leave everything that you thought that you knew about this case at the door. I saw you all waiting during the case at the edge of your seats, waiting for the state to bring you, like she says, the smoking gun that she was involved. Where's that? Where? Was it Luis Rivera? The worst witness to have ever existed on the face of the planet. I have never seen anything like that before in my life. They are asking you to convict Ms. Magbanua on the word of a man who was proven to be nothing more than a liar and who only cares about himself. You are the jurors in this case. You saw the evidence that they brought into this courtroom. That is what you have to base your decision on, the evidence that you saw here. Leave everything outside the door, members of the jury. This is us in here now. We have all been through this together, all of us. The judge, everyone. But it's what it is that you learned, because that's the evidence in the case. Not what's out there in the media, not what is other people's interpretation of what they believed happened in this case. I'm sure you expected way more when you came in here on this case. I'm sure you expected to be like, oh wait, they're going to give me something. And that's what they gave to you. That unreliable word of Luis Rivera, and nothing more. Go back and listen to the Dolce Vita. That's how confident I am, because I know for a fact there's nothing on there, because she is innocent. Justice for Dan Markel is not convicting an innocent person of this crime. In fact, it would be a travesty of justice to convict Ms. Magbanua of any of the charges in this case. She is across the board not guilty. And remember, members of, she had nothing to do with this. That's what we're telling you. Nothing, no part of it. The state is throwing all of these charges at you, hoping and praying that just one of them will stick. That's all they want, just one. But I'm telling you, she is not guilty of all 3. Because if she didn't know, members of the jury, she's not guilty. You cannot convict her for having awful taste in men. You cannot convict her because the father of her children is a scumbag. You cannot convict her because she ended up dating Charles Adelson, probably one of the worst human beings on the face of the planet. She didn't know, members of the jury. And what the evidence in this case has proven to you is that she is not guilty of every single count. Please take the time to evaluate the evidence in this case. We have come this far. I'm confident that when you all sit there and you go over everything for yourself, you're going to see that she didn't do this, members of the jury. She's innocent. Find her not guilty.
Thank you, Ms. Claus.
Thank you. Thank you.
Ms. Kappelman, state rebuttal. You have 10 minutes.
So unfortunately, I cannot take up Mrs. Colos's invitation to explain to you why it is that criminal defendants choose to exercise their constitutional right and take a case to trial as opposed to doing a deal or taking a plea offer. Maybe she thinks she has very talented lawyers. Maybe she thinks she has a good chance of walking out of here. Maybe she thinks if she gets convicted, she'll offer to do something for me then. We'll see how that goes. Maybe she's getting a big payoff. Maybe somebody's threatened to do something to her. I don't know. And that's not important. I don't have to prove that to you because it's not an element of the offense in this case. Y'all really have to focus on what are the elements and have those been proven. A lot of the things that were suggested to you that I haven't proven, I don't have to prove. So I want to make sure you take a look at those elements when you get back there and think about what evidence do we have in this case to each one of those elements. The defense says none, there's nothing, we've just been sitting here for 10 days and nothing has occurred. That's going to be up to y'all. Did the case get proven? Was the evidence any good? That's up to you collectively and individually as jurors. Am I hiding things? Am I filtering things? You cannot speculate on items that did not come into evidence. The judge is the filter. What comes into evidence? This stuff over here in the testimony, you guys have to base your verdict on that. And if that's not enough, then it's insufficient evidence, lack of evidence. That can give rise to a reasonable doubt. But as far as, oh, we tried to get in this thing and y'all didn't get to hear it and they're hiding it and it must be something really good, that's speculation. That item is not in evidence because it was not admissible and you cannot speculate about it. Please do not accept their invitation to do that. The judge has instructed you that a reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. So y'all have to really assess what is reasonable when you're back there. And you were chosen because you have common sense and you know how to do that. It's not magic. I want to address some of the coincidences that really you have to buy in order to buy the defense theory in this case. I mean, everyone sort of agrees. You look at it and you think, yeah, she's in the middle. In order to buy the defense's theory that this evidence is not as it appears, you have to find that there are several things that are coincidences, and I'm sure you can think of a lot more, but I wrote down a few. Fact one, the defendant went to the rental car place. Okay, I mean, there's evidence she went to the rental car place. She says, no, I was visiting Kenya. But God, what a terrible coincidence that she's visiting Kenya both times that the rental car is getting rented and returned. Fact two, the money spike in this case. And you all have seen repeatedly that graph with the big spike in her cash that occurs right around the time of this murder. And she says this is not as it appears. I worked in the club, I made a lot of money, I happened to have the best month ever that month that Dan Markel was murdered, but that has nothing to do with me. The cash spike is not evidence of a crime. It's a coincidence. Or Sigfredo Garcia gave it to me, but remember that Yinder told you that the defendant went after Sigfredo Garcia for child support in January of 2015. So it's a little unbelievable that after, remember she said, getting $1,000 from him would be a very significant amount of money. If she had just gotten, $13,000, $14,000, $17,000 from him between the murder in October the year prior, would she be going after him for child support in January of 2015? Is that just a, this money situation, is this just a terrible coincidence for her? Is it a terrible coincidence for her that she got placed on the payroll of the Adelson Institute and it just happened to be right after the murder, and it just happens to be that she really doesn't seem to be able to tell us what she did for it? Fact 3, Rivera flipped on her. He did. He flipped, he told what he knew, and she went under the bus as a result. Well, he's making up his testimony to comport with the reports in the case. He's a liar, he's a gangster, he's a thug. You shouldn't believe him. And she's just the unlucky victim of his made-up story to frame her? He's a liar, as are all the witnesses in the case, right? I mean, they kind of have to all be liars. Why didn't I just have Luis Rivera, since I'm also a liar and a crook who's trying to pull the wool over your eyes, why didn't I just have Rivera say Garcia did it? Charlie Adelson did it. Why didn't I just do that? I'm desperate to get Charlie Adelson, aren't I? I'm laying awake at night wanting to do this trial again. Why don't I just get Rivera to say whatever I want? That's what I'm doing, aren't I? Fact 5, deep sea fishing. Or maybe I'm on 4. 4, deep sea fishing. Look at this text. They made a joke about deep sea fishing. The problem is, and we published State's Exhibit 133, a clip from the defendant's prior testimony where she admits that was a joke. I am unaware of any evidence that Garcia and Rivera are in direct communication, and I'm not sure why my lawyers were trying to make it look like there was a connection between those two. She didn't even get what they were trying to do. Fact 5. This is the biggest fact. I mean, she is literally in the middle. She is got a baby daddy who killed Dan Markel and a boyfriend who hired the hit. And she is to have you all believe that that is a coincidence. Her child's father, having nothing to do with her, happened to murder the brother-in-law of her boyfriend. It is often said that the best explanation is the simplest one. So we're up to 5, and I'm sure you can think of more explanations for the appearance of this case. Or one explanation, one that is simple and explains everything and is, I think, very well articulated and proven by the evidence that y'all have been held hostage and forced to listen to and see for the last 10 days. How many coincidences does it take for it to no longer be a coincidence? I want to talk about the defendant's own words. She sent a text message to Charlie Adelson in 2015 that says, next time, don't be such a dick to someone that has done something for you. Where's the record? What has she done for him? Sorry we have problems sleeping and shit. We do have a lot of weight on our shoulders. Remember what Donna Adelson said to June Umchinda out on the balcony that day? She feels like Dan is haunting her from the grave. The weight of this thing is heavy on these people. The weight of this crime is inescapable, and it is squarely on this defendant's shoulders. She didn't come to Tallahassee. I can't give you a picture of her in Tallahassee. I can't put her in the Prius because she wasn't in the Prius. She didn't come to Tallahassee. She didn't pull the trigger. But she's as guilty as everyone else that had a part in this crime. No amount of playing dumb, no amount of criticizing the cops and the investigation. If the facts aren't on your side and the law aren't on your side, attack the prosecutors. Attack the witnesses. Attack the cops. Attack the investigation. No amount of excuses and explanations for the evidence in this case can change it. The truth is the truth. The evidence is what it is. The defendant has asked for your sympathy, and you may have felt sorry for her yesterday. We talked about sympathy at jury selection. It is sad. It's sad for everybody involved. But the judge has instructed you that your verdict must not be influenced by feelings of sympathy. You have to separate that out. In her own words, those are the most damaging pieces of evidence in this case, not the words of the Katie that you saw on the witness stand yesterday, but the Katie that you met in those phone calls. It's getting too detailed. That's call Z. It's getting too detailed. It's somebody that knows for sure. Or call GG. It's not from the inside because there's too much from the inside that the other person knows from the outside. That's why I know for a fact it's not from the inside. It's somebody trying to be greedy. Her own words are the thing that hangs her worse than anything else y'all have seen. Defendant says everyone has their own versions of the truth. I want Rivera to say my truth, his truth, her truth. No, there's only one truth. And that's what you all are going to decide in a few moments. One truth, which is determined by the evidence. One verdict in this case that speaks the truth. What Katherine Magbanua is going through is not the worst nightmare that anyone can imagine. Her being compelled to answer for what she did in this case, for what she set into motion, that is not the worst nightmare that anyone can imagine. This is what this case is about. Find her guilty. Thank you.
Right. Thank you, Ms. Kaplan. Okay, I'm going to read the last instruction to you. So if you go to page 11, please. In just a few moments, you will be taken to the jury room by a bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all the jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room during deliberations. Kindly leave those devices with the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to use the audio headphones provided in the courtroom, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. All right, so you'll be taking your instructions back with you. Also, a short instruction in regards to your notes. You may also take any notes that you took during this trial back to the deliberation room. As previously instructed, your notes are a tool to aid your memory. You should not compare your notes with those of other jurors in determining the content of any testimony or in evaluating the importance of any evidence. Notes are for the note-taker's personal use in refreshing his or her recollection of the evidence. They are not evidence, and above all, your memory should be your greatest asset in your recollection of the evidence. All right, at this time, I need to discharge the alternate jurors. We have 2 alternate jurors who will not be going back to deliberate in the jury room. And the alternate jurors are Ms. Crump, you are an alternate juror, and Ms. Gilliard, is it Gilliard? Ms. Gilliard, you are also an alternate juror, okay? I want to thank you very much for your service. You have been extremely dedicated, and I know that you've sat here for the 2 weeks, and you're not going back to the jury room, but it wasn't all for nothing. We appreciate all your time and efforts in regards to this case. The bailiff is going to escort you back to the jury room so you can gather any personal belongings, and then you'll be excused out the back door, okay? You can leave anything that you have right there on your chair, any notes or the jury instructions. All right, thank you both very much. Okay, once the deputy has returned to tell me that they are out of the jury room, then you will be going back to begin your deliberations, okay? Lunch is back there waiting for you, and so that will be provided for you. And so the timing of your deliberations, of course, is now completely up to you, okay? So we'll just wait just a moment for the bailiff to return. All right. Okay, the deputy will now take you back so that you can begin your deliberations. Yeah, you need to gather that. Yes, okay. The jury's back in the jury room, and the door is closed. The deputy's gathering their phones at this time. And so for the record, any objection to the jury instructions as read from the defense? Any objection to the jury instructions as read?
No, sir.
Thank you. All right, and I'm going to ask one member of each council team to come up, take a look at the exhibits before we send them back. I want to get on the record that there's no objection to the exhibits that are going back. I know you've made other objections during course of the trial, but I want to make sure that you view those, and also the verdict form, and then we'll take those back to the jury. The attorneys can leave their cell phone numbers with Madam Clerk, okay? And then if we hear from the jury, either with a verdict or with a question or otherwise, then we will notify you, but please don't go far so that we can gather back in the courtroom promptly, okay? So if two of the attorneys can come on up and take a look at the exhibits so that we can send those back to the jury along with the verdict form.
Did two of us come on?
Just one. That's all that's necessary. Ms.
Judge,
Kaplan?
may I be permitted at this time to introduce a couple items as court exhibits for the record? I have the Dolce transcript, the emails, the wire call transcripts, and the closing PowerPoint. I'd like to have those marked as court exhibits.
Okay, so so exhibits that are not going back to the jury, just as court exhibits for the file?
Yes, sir. Based on your prior rulings, they're not to be used, but I want to.
All right, we'll put those into the file. And Madam Clerk, will those be numbered or lettered or how?
I'll be numbering those, and they'll be numbered course exhibits starting with 1.
Okay. All right, so court's exhibit, and those will be numbered, and we'll take special precautions to make sure that those don't go back to the jury. Okay. All right, who's going to take a look at the exhibits for the state? Okay. And Mr. DeCoste, you for the defense? Yes, sir. All right, then I want to get that on the record, please.
No, I missed everything up there, right there. It would have only been the 2 text messages and the diagram.
Ms. Kaplan, you're satisfied with the exhibits going back to the jury?
Yes, Your Honor.
Thank you.
They just put cones out. I don't think they have. Would you close the gate?
All right, it's my understanding that we have a question from the jury. All right, it says, Judge, could we please get an inventory list of the evidence so we can navigate what communications are here? And it's signed by the foreperson.
Your Honor, I've made a copy for them and for the parties, and I've highlighted the state's columns in pink and the defense columns in yellow.
All right, so this is the criminal exhibit sheet that is prepared by the clerk, which lists both the state's exhibits and the defense exhibits, and a short description of each exhibit. All right, have both parties had an opportunity to take a look at this?
Yes, sir.
Okay, and any objection to this going back? Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Okay, all right, so we will send this back. The criminal exhibit sheet. I guess we should mark it in some form, since it's going back to the jury.
As a court's exhibit.
As a court's exhibit, yeah. So let's mark that as a court's exhibit, since it's going back.
Your Honor, to keep this separate from the previous court's exhibits, I'll call this an A, if that's okay with you.
Please. I'm trying to remember everybody right now. All right, and if you could keep this note for the court file, please. And we'll send this exhibit sheet back through the deputy, and then we'll be back in recess, okay? All right, thank you. All right, we're back on the record. We have a question. All right, so, Your Honor, could we please get the headsets for an audio file? All right, so they want to use the headsets, and so we're going to have to bring them back into the courtroom for that. So they're going to need to identify what they want to hear. Okay. All right. My proposal is I'll just write a response and I'll state, we will need to bring the jury back into the courtroom to hear an audio file with the headset. Please identify the audio file and we will prepare it for the jury. Sufficient?
No objection.
Okay, all right. Let me write this down then. All right. You could please take that back to the jury, and once they review it, and then get their response. Yes. Thank you.
overrides the audio.
Can't be playing.
Let's test it. Well, I'm gonna drag it to my desktop.
All right, we're back on the record. Please prep the Dolce Vito audio/video. Do you need the video disc? Yes, the one that's in evidence that they have in there, correct?
We have it loaded onto our desktop.
I want to use the one that's prepared in evidence. Okay. All right. So could you just form them that, I mean, we can play that pretty readily, right? It's not going to take us much time. So if they could provide us with the disc, and then we'll bring them right out to watch the video. Yeah, it's a thumb drive? Okay.
Given the fact that they are in deliberations, that we cannot be in the room, that the only person that can be in the room is going to be the bailiff. Because otherwise, you've got other people interacting with them during their deliberations.
And watching them while they're listening.
They may also have the view that we wait in here and remain while they make their decision, which could force them to go faster. Having dealt with this before, I believe the appropriate way is that it is set up and it is played by I'm sorry, I don't know how to refer to bailiff or Leon County Sheriff's Office to have that then played, but that everybody is outside of the courtroom.
Well, I mean, I've never done that before. I mean, I've probably done this 2 zillion times, but if that's what you're requesting, do you have any, I mean, is there any case law that supports that? I mean, I think they know we're not sitting around waiting here in the courtroom, but so I don't think that's an issue. But if you're saying that there could be some influence on the jury because they're in deliberations and we're sitting in here and they're watching the video,
Yes.
do you have an objection to, well, somebody's going to have to put it in and play it.
Correct. I believe that it should be court staff, not any of the parties.
I don't think I have any court staff here at this point.
Do you have case law? If you would allow Ms. Quast, Kristen Quast, you can address it. There is case law on this.
I'm sorry, I'm looking on my phone because I've just had to read my computer, but, Wright versus State, the site is 300 Southern 3rd, 1243, District Court of Appeal, 3rd District from 2020. And it says that the trial court's not required to be present when jury views a muted cell phone video audio, as long as it's not a readback of testimony, as it, like audio.
The trial court is not what?
Required to be present when they ask to have anything played that's not testimony.
All right, well, I'm not required to be present.
But
That
no,
doesn't mean I have to clear the courtroom.
I'm sorry, Your Honor, I'm just now looking this up, but I mean, that would still be our position, that we would prefer that no one would be in there. I can continue to look though, Your Honor. I'm literally on Westlaw on my phone.
All right, I'm going to deny that request. We do this routinely. I don't think the jury, we're not going to have any discussions in here. Nobody's going to say anything. I'm going to bring them in. I'm going to sit them down. I'm going to tell them we're going to play the audio and video for you right now. We're going to turn it on, and we're going to let them, they're going to see it, and then we're going to go back and bring them back so that they continue their deliberations. They're not going to be talking or saying anything, nor is anyone here in the courtroom. Okay? If you could please escort them out along with the video disc, please.
But if we could have the 116 first, so to make sure it's queued up before we bring it in.
Okay, disc 1, so exhibit 116. you could please provide that to council.
Katherine, I gave you the wrong one.
Deputy, if you could give that back to them now.
Deputy, that's what he said. I had a moment of hesitation.
Ms. Dugan, these exhibits are marked both on the bag and on the flash drive itself? And that flash drive says what? 116? Yes, sir. Okay, thank you. All right, it's queued up from the start?
Yes, sir.
All right, let's bring the jury in, please. All right, please be seated. We will now play Exhibit 116 for you, along with your use of the headphones. Okay, Madam Court Reporter, if you need to use these headphones. Okay, all right. All right, you may proceed.